Welcome back to Risk Management and Insurance. Today we will be going over the Unit 6 material, which is a review of the workers' compensation system. You may or may not be familiar with the workers' compensation system, and if you are familiar with it, it may be because of the purchase of workers' comp insurance for your company, or you may help administer workers' comp for your organization if you are in the HR department. You may even be familiar with the system because you've had a workers' comp claim yourself at some point in your working career. Workers' compensation is defined in the text as social insurance, but is much different than the other forms of social insurance like Medicare, Social Security, and unemployment compensation. And in this unit, we will talk about workers' comp and discuss how it is managed as an operating cost for organizations. But let's start out by looking at the history of workers' compensation. In the period of pre-1911, there was no workers' comp system, and if a worker was injured on the job, he had to sue his employer in order to be compensated. This meant that the burden on the employee was to prove that the employer was negligent and therefore responsible for their injury. Think about the time period. The country had gone through the Industrial Revolution and was modernizing, but factories and workplaces were often dangerous, dark, and dirty. Safety was not on anyone's mind, only production. During this time, workers suffered terrible and crippling injuries, often in factories, and if they were not able to successfully sue their employer, they became a burden on their families and at times on society. And at that time, there was also not a big safety net. If a worker was injured and was lucky enough to have the money to hire a lawyer, the employer had three defenses that would be argued against the employee. And these three defenses were, first, the assumption of risk. The argument was that the employee knew of the dangers of the job, and by taking the job, he assumed the risks of injury. That sounds pretty harsh in today's world, but it was commonly accepted back then. The second defense is the fellow servant defense. And often a co-employee was involved in some extent in an accident, and the employer would argue that it was the fellow employee's fault and not the employer's. And the third and final defense that was often used was contributory negligence. If the employee did something that was partly responsible for the accident, it was then his fault. This was a particularly effective argument, as in most accidents, even today, the employee often does something, some lapse in judgment or violation of safety rules that led to the accident itself. So while this was the system here in the US, there was also European influence called employer's liability. And employer's liability was the standard in Europe, and under it, the employer would be responsible for the employee's medical bills and lost wages if the employee was injured at work. And since there were so many immigrants from Europe, this cultural background started to have an influence in how people viewed the system here in the United States. So by 1911, society was becoming more troubled by these terrible industrial injuries and the perceived inequity between employers and employees. The sentiment was starting to impact some of the lawsuits, and employees were starting to win and win larger dollar amounts. Employers were becoming concerned about this legal trend, and some employers were also interested in providing a fair result for their injured employees. These factors led to what became known as the Great Trade-off that today is the workers' comp system. And it's a surprise to some that the legislation was led by employers at the time. The employer would provide medical and indemnity benefits, lost wage benefits, and the trade-off is that the employee would give up the right to sue the employer. Now, the first workers' comp law was passed here in Wisconsin in 1911. Unfortunately, it was thrown out by the courts and had to be rewritten, and by then, other states had started passing workers' comp laws as well. But we can all be proud that Wisconsin is where workers' comp started. Now, workers' comp is what's called a no-fault system of benefits. The employee does not have to sue and automatically gets covered, subject to some conditions. And under a no-fault system, and under workers' comp, the tie always goes to the claimant in the system, and that's by design. It's meant to minimize the amount of attorney involvement in the system, which helps to keep costs down. And again, it's part of the trade-off. Workers' comp is also meant to reduce societal burden. the employer has to fund the benefits, and it just becomes simply a cost of doing business. And then they work that into their product cost. The employer can buy insurance for workers' compensation, thus shifting the risk to the insurance company, and then it becomes a much more stable cost and it's easier to budget. Now, workers' compensation is considered compulsory for employers, except for some exceptions such as farms, domestic workers, and small employers who maybe have up to 3 or 5 employees, depending on the state. And speaking of the state, the workers' comp system is very state-specific. So each state has its own laws, and there's variations in benefits and variations in how it's administered. But in general, the benefits and legal theories are fairly similar across the states at a high level. So now let's talk about the benefits under most of the workers' comp acts. And the first general benefit is indemnity, which really are the wages that you have lost from being off of work due to an injury. Most states have 2/3 replacement of the employee's average weekly wage as salary for the week, replaced subject to typically minimum and maximums set out by the state. Medical costs are also covered by the insurance, and this would include all medical costs that are related to the injury with no deductible and no coinsurance, and no cap at all. Also, allocated loss expenses, which are the costs related to the handling of the claim. The insurance company would take care of this, or if they're self-insured, the employer would. So let's go back and talk about each of these coverages, starting with indemnity or lost wages in a little more detail. There's really four general pieces to lost wages, and the first is temporary total disability. Temporary total. So you're completely off of work, totally off of work due to the injury, but it's for a temporary period of time. And you're expected to return to work when healed, and when healed sufficiently to be able to go back to work. So workers' compensation pays to replace your wages subject to the provisions we previously discussed, typically 2/3 of your prior injury wage. The next broad category of indemnity is temporary partial disability. So again, the emphasis is on temporary here. You're expected to go back to work full-time, but because of the injury, you can only work part-time while you're healing. So the workers' compensation pays to replace a portion of your salary that you've lost during this time. The third category of indemnity is permanent partial disability. So permanent, you've got a permanent disability, so a permanent reduction in your wage potential. And it's either by being able to being only able to work part-time, or more commonly by not being able to go back to your previous employment and having to take a job that pays less. So workers' compensation is going to pay for the difference between your pre-injury wage and what you're now earning as your new earning level. And then the fourth category is permanent total disability. And what this really means is you're never able to go back to work. And workers' compensation is going to pay for your lost wages until either your normal retirement age or your death, depending upon the state law. And if it pays to your normal retirement age, then the presumption is that you go into Social Security then through your retirement. Now, there is a fifth category of indemnity payments, and that's if you die. So if the accident results in your death, workers' compensation will pay certain end-of-life benefits, but then also pays ongoing lost wages if you have a surviving spouse or minor children. These benefits do not go on forever, but only until the children become adults and until the spouse either remarries or after a set period of time, depending on the state law. And there is some variation across states here. Some of them take the children through college, and others don't. Now let's go back to the medical costs, the second part of the benefits. And they're usually defined as reasonable and necessary to relieve or cure the effects of the injury. Now, rising medical costs are having an impact on workers' compensation insurance, just as they are in health insurance. And the costs, as you can imagine, would range from everything from the hospital costs, either ER visit or if you have to be hospitalized, the fees for the doctors, physical therapy, and physical therapy is used quite extensively in workers' compensation. prescription, and really all drugs. And this is becoming a much bigger cost these days as a percent of workers' compensation than it has in the past. Now, the third and final part of coverage are the allocated loss expenses. And these are covered by the insurance for the employer or paid for by the employer if they're self-insured. And they're going to include such things as an independent medical exam. And where this comes into play is if there's a disagreement with the employee about whether or not the injury was work-related or whether or not the employee is healed enough to come back to work. And they might have dueling doctors, and the insurance company will get this independent medical exam to give an opinion. The next part of allocated expenses is medical cost containment, such as PPO fees, preferred provider organization fees, and bill review. So you might be familiar with this under health insurance, and it does have some similarity. Basically, these are audits to make sure that the medical bills are correct and reducing to negotiated fees with the providers to take advantage of purchasing power by the insurance companies. And these savings typically are passed on to the employer. Defense attorney fees. Now, workers' compensation was supposed to be a no-fault system with no attorney involvement, but particularly if the employee has hired an attorney, then the workers' comp insurance company has got to hire an attorney. So in some cases, the employee feels that he needs an attorney to protect his rights. And in other cases, the attorney has just done a very good job convincing the injured employee that he needs an attorney. Now, there are certainly some workers' comp disputes where you have to get an attorney to protect your rights. But industry studies have shown that typically once the employee pays the attorney out of her workers' comp settlement, she's not going to end up with any more than she would have gotten just negotiating on her own with the insurance company. Now, the next part of the indemnity fees are surveillance and background checks. And this is a case where perhaps one employee tells the foreman that the injured worker was out working another job while off on workers' comp, or that they were putting a new roof on their house. Sounds outrageous, but it does happen once in a blue moon. And it really is a sad thing because the vast majority of workers' comp cases are valid injuries. But there are a few people out there that are looking to cheat the system, and unfortunately, because of that, then sometimes everybody feels like they're being treated as if they are cheating. Now, case managers and rehab nurses, this is really distinct from the PPO fees and the audits. What this would be, particularly in severe cases, the insurance company would pay for a nurse to actually kind of be the patient advocate working with the doctors to help make sure the appropriate treatment is done. Not too much and not too little, but and at sometimes actually provide more medical care than typically the health insurer would want to provide in order to bring the employee back to work as soon as possible. Because the insurance company and the employer want to do everything to try to minimize the total cost, and historically the lost wages have been by far the biggest cost. Medical bills are getting to be a little bit bigger these days, but really the whole goal for most insurance companies and most employers is to get the employee healed as quick as possible and back on the job, because typically studies have shown that they'll even heal faster if they are active and involved with something rather than just sitting around home shuttling around to doctor's visits. So it's a little bit of a balance of willing to spend more medical in order to cut down on the indemnity. Now that we've talked about the benefits, let's switch over to talk about deciding if an injury is covered under workers' compensation or not. So we're really talking about what determines the liability for workers' compensation for an employer. And there's really several key conditions that have to be looked at. The employee has to sustain an injury. And at the time of the injury, both the employee and the employer are subject to provisions of the Workers' Compensation Act in the state, or the state where they're trying to claim benefits. And at the time of the injury, the employee is performing service growing out of and incidental to employment activities. We call this in the course and scope of employment, or in the course of employment. And the accident or disease that causes the employee's injuries need to arise out of employment. So they need to be in the course of employment and need to arise out of employment. and the employee's injury is not self-inflicted. Now that would seem to just be make sense and be self-explanatory, but we'll talk about how that's not always clear-cut. So the bottom line to these things is really a three-point test. And as mentioned, the injury needs to arise out of the employment, needs to be in the course of employment, or the employee needs to be in the course of employment. And the condition, which we can consider a traumatic event or an occupational disease, is causally related to the employment activities. So the first two, arising out of employment and in the course of employment, is really a statutory in nature, and it's ruled on by the sole fact finder based on controlling case law. And causally related is determined by a recognized practitioner. And here in the state of Wisconsin, a recognized practitioner would be a medical doctor. So the doctor needs to determine that the injury was really caused by and related to the employment. So let's talk a little bit more about medical conditions that are covered under workers' compensation. So accidental injury, kind of a traumatic, fortuitous event. It's unexpected and unforeseen by the injured person. Get injured in a punch press. A salesperson is in an auto accident. And despite what some employers would like, stupidity is not a viable reason to deny workers' comp benefits. Because the sad fact is that typically the majority of injuries out there are the result of the employee either ignoring safety rules or just having some lapse in judgment. But we have to remember that employees have to work in dangerous conditions, and the employers have to engineer out the dangerous conditions in the workplace. But it's these behavioral issues that really remain the number one cause of accidents. And I've seen it time and again. The other type of injury or non-injury that's covered is occupational disease. So this would be a non-traumatic event, tendinitis, carpal tunnel syndrome, silicosis, asbestosis. Some of these things certainly you've heard about, heard the lawyers advertise for them on TV. And the key for coverage with these types of illnesses is that they have to be developed on the job, or they were aggravated, the condition was aggravated on the job in order for there to be coverage. So let's go back to the arising out of employment. Let's just take another overview of it. So where the obligation or circumstances of the employment place the employee in a particular place and at a particular time where he or she is injured by a force that really isn't just solely personal to him or her. So the hazard needs to be unique to the employment situation, and it has to be greater than what the general public faces. Now, what does that mean? So if you slip and fall on a wet floor at your place of employment, that's going to be covered under workers' comp. But if you simply trip over your own 2 feet, you could do that at home as well, and it's not necessarily covered. That seems to be a very fine point, but it's something that needs to be looked at. Intentionally self-inflicted injuries. Now, the fact that an employee's injury is the result of his or her own negligence, even if the negligence was willful and wanton, does not make the injury intentionally self-inflicted, which raises the question of suicide. And the Wisconsin Supreme Court really takes a liberal approach to evaluating suicide as a compensable result of injury. It can be compensable if the claimant establishes, or their estate establishes by substantial evidence, that a chain of causation exists linking the suicide to a compensable industrial injury. And we also need to talk about a non-traumatic mental injury. Workers' comp coverage exists only if the injury resulted from extraordinary stress. So the stress needs to be much greater than what typically would be faced by an employee because of the job. So if it's just normal stress with a normal job, then an employee here in Wisconsin and most states cannot apply for workers' compensation coverage. Okay, well, now let's talk about a compensable non-traumatic mental injury. And this would be where an employee So you're in the course of employment, the scope of employment, and you witness a terrible accident, or perhaps you're being harassed by other employees. If you develop a mental illness or depression or something over this, then that is covered. But we also want to make sure that we distinguish that between a traumatic mental injury, which is compensable. And doctors are very familiar with this, that perhaps if an employee loses a limb in a machinery or an accident, and then they develop depression over it, the depression is directly tied to the injury and therefore is completely compensable. And you will not find any insurance company try to deny that type of claim. So let's turn back then to that course of employment overview and some important issues regarding it and things that actually have been litigated. So there is a presumption of continuing employment. So when it's established that the employees have entered into the performance of their duties and are found at a place where they might properly be in the discharge of those duties, and there's nothing appearing to be the contrary, then the presumption of employment is maintained, and any injury is going to be compensable. So whenever you're performing activities that are normally associated with your job, you're on the job and you're covered by workers' compensation. So the main question in course of employment assessment is whether there was a deviation from the work and a sufficient deviation from normal work activities to remove the injury out of this presumption of continuing employment. So any of us as employees, it's presumed that we are employees unless something happens. There's the personal comfort doctrine. So employees on a coffee break, maybe even a lunch break, a smoking break, you're walking to the washroom, you're getting fresh air. Typically, if you get injured doing one of these things, it's going to be compensable because in some ways you're temporarily abandoning your job, but it's not so unusual that the conduct considers to be out of the scope of employment. But now let's talk about going to lunch off the premises. If I went out to McDonald's for lunch today, while I'm gone, I'm not covered. What if I'm out to lunch at someplace nicer and I'm taking out a client? So it really is it's a business lunch, business related, and I would be covered under workers' compensation. If I got in an auto accident on the way there, if I choked on lunch, I would still be in the course and scope of employment. And if I choked and died, then my wife would collect a big workers' comp check. And hopefully she'd be sad and miss me. So if you're in the course and scope of employment, a momentary deviation, even just a small deviation, if it's impulsive, it's momentary and insubstantial, may not be sufficient to remove the employee from the course of employment. If you're stopping at a drugstore or making sales calls, that does not necessarily take you out of the course of employment if your job typically has you running around out of the office all day. Now, what about horseplay? Employees participating in horseplay may still be compensated if they are injured, depending on the following factors. What's the extent and the seriousness of the deviation from employment? And what's the completeness of the deviation? Was it so bad that it was really an abandonment of their duties? And what courts will look at, if this is litigated, it's the extent to which the practice of horseplay has become an expected part of employment. So that means, was it tolerated? And if it was tolerated, an employer cannot come out and try to deny coverage for workers' comp if somebody gets injured while they're horsing around at the office or at the plant. So this is one of the big reasons why employers should actively stop horseplay, and you'll find that on job sites and factories and construction sites, supervisors have really stopped this over the last 20 years. Now maybe the next step up from horseplay is, what about fights? Most case law has been pretty clear that once an employee deliberately engages in a fight with a co-employee, he or she has stepped out of the course of their employment, and if they're injured, they're not going to be covered under workers' compensation. With maybe a couple exceptions, and that would be defending yourself. If you're not the instigator and you're merely defending yourself from another employee, you are probably going to be covered under workers' compensation. Now, it's a surprise to many employers, and also probably to a lot of you, that intoxication does not by itself constitute evidence of deviation from employment. A lot of people think that it should, that if you're drunk and on the job and you, say, cut your hand off in a punch press, that you shouldn't collect workers' comp, but in most cases you are going to collect workers' comp. Let's turn to the topic of parking lots. What if you slip and fall and injure yourself in a parking lot? There's been a lot of case law on this. And an employer's designated parking lot has generally been considered to be part of the premises. So the next question then would be if it's owned by the employer and you're injured, it can be workers' comp. But if your parking lot is not owned by the employer and you're walking through the parking lot or walking to work, you're not necessarily covered by workers' compensation, and you're probably not covered. But what if the parking lot is controlled by the employer but not owned? And what about the sidewalks? Well, a lot of cases, it really comes down to the case law, and it varies a little bit from state to state. But a couple of cases have really been a divergence of opinion. And here in Wisconsin, there have been several cases that have really held that if the sidewalk is the employer's sidewalk and the employer owns the sidewalk, it's on their premises, then you're going to be covered. But if it's, say, you're employed in a high-rise downtown and somebody else owns the sidewalk and it's not part of the employer's premises and the employer has no exercise control over it, then it's not going to be considered workers' compensation. So while there's a little bit of a divergence of opinion, if an employer does not own the sidewalk but starts to some ways to exert enough control over it that they really have become the de facto owner of it, and you slip and fall, say, on an icy sidewalk, you probably can start to get workers' compensation benefits there. So in a lot of cases, it's going to depend. And that's when people start getting attorneys involved. Now, there's also a coming and going rule. So an employee is in the course of employment while going to and from his or her employment in the ordinary and usual course of business while on the employer's premises. Again, it comes back to the employer's premises. Now, what about the Christmas party or the company picnic? So recreational functions off the premises. And recreational activities with customers, such as hunting and fishing trips, are not deviations from employment, especially if the activities are authorized or directed by the employer. So the company picnic, company fundraising event, the real evaluation is the employee subject to employer's rules of conduct during these events? It's a part of the job description. For many managers, it is. Is the activity part of your job evaluation? For a salesperson, you betcha. Is the attendance required, even if it's an unwritten requirement? Often at company parties, managers are told they have to attend, and sometimes just regular employees are told they have to attend. That really makes it more workers' comp than not if something goes wrong. And does participation in the event benefit the employer? Other things that past case law has come to look at and that courts look at when they're evaluating this, and now insurance companies do as well, is was the event designed to improve employee morale? So the more that these things are answered yes, the more likely it is that if you get injured doing them, it's covered under workers' compensation. Now that brings us to I think the next logical step is, what about travel? Let's start out with commuting. And the typical employee commuting to and from work is not going to be covered until he or she reaches the employer's premises. However, if the employer provides transportation or pays for the transportation, an injury during the trip is all of a sudden compensable. Carpooling, an employee who voluntarily participates in a private group or even an employer-sponsored carpool, van pool, or commuter bus service, or any other type of mass transit or rideshare program is not considered in the course of employment. But traveling employees, so you're not commuting now, but all of a sudden you're traveling on business. And this could be a once in a blue moon trip for training or to the home office, or this can be a salesperson that's traveling every week. So employment that requires travel, and any requirement of travel, is deemed to be in the course of employment at all times while on a trip. And this really becomes 24-hour coverage. The only exception is when engaged in a deviation for a purely private and personal purpose. Personal comfort doctrine comes into play here. So while you're eating, sleeping, showering, reasonable recreation, they're not considered deviations. So what about a trip from home to another store or another facility? If you take a reasonably direct route, the employer has a burden to prove that the employee deviated from the course of employment. What if the trip has a dual purpose, both work and personal? And that really becomes a question of fact for an administrative law judge, and typically they're going to try to find coverage for the employee, particularly, especially if it's a serious injury. And here's one that always really gets employers, is returning to premises after separation from employment. So you fire an employee over the phone and you tell him to come in and get his paycheck, and he slips and falls on the premises while he's getting that last paycheck. That is workers' compensation, because he's presenting himself at the usual place for the purpose of collecting his pay. So you're better off just mailing that last check. Return to work premises within a reasonable time after separation. And again, I guess it comes back to what's a reasonable time. Now, another thing that's come up much more in the last 5 or 10 years or so are wellness programs. So participation in wellness programs, whether on or off the premises, does not place an employee in course of employment unless the program is mandatory or compensated. Now, wellness kind of makes you think about, well, why do we have wellness programs? We're all trying to get healthier. And every once in a while, an employee gets hired by an employer who perhaps has an injury or something that makes them more susceptible to an injury. And there's really an as-is rule as to aggravation. An employer takes an employee as is, kind of like buying a used car. So anything that's unique about that employee that makes them more susceptible to an injury or collecting a workers' comp claim, it doesn't matter. If they have an injury or if they aggravate something during the employment, then they are going to get workers' compensation coverage from that employer. So it's really regardless of a pre-existing condition. An example to look at is the hernia. So if you have a hernia and you start working at a place of employment and you're lifting something and the hernia all of a sudden becomes aggravated and you have to have surgery, that employer has just bought that claim. Now, what if you're in treating that hernia and the surgeon actually messes up, and because of the surgeon's error and really malpractice, it becomes a much more expensive claim? The employer is still responsible for it. Now, the employer might have the right to go back and sue the doctor, but the malpractice of the injury is no reason for the employer to get out of covering the injury. So one thing to keep in mind is the causal relationship that has to be there in order for there to be coverage. So the causal relationship the activities have to be a contributing factor to the condition, not the sole contributing factor to the condition. So that finishes this portion of the unit. We'll also be speaking with an industry professional in another segment of this unit to hear some real-life examples of the complexities in the workers' compensation system. And I will see you again in Unit 7.